Before we get started, I'd like to introduce our team that'll be presenting this first session today. We've got our veterans, our more senior healthcare lawyers. These names will be familiar to anyone that's worked with the firm or attended Health Law Institute in the past. We've got Dick Hay and Stan Andiel supporting us this morning on the panel. We've also got Alex Schulte, Clayton Kaiser, and Amanda Wilwert. All three experienced healthcare lawyers that have presented at Health Law Institute in the past. And we've also got Gabby Grouse, who is going to be a newcomer, a new face. She's one of our new healthcare associates that joined us last year, and we're thrilled to have her as part of the team. So we appreciate your attendance today. We're excited and we think we've got a great program that covers a lot of different topics from state issues, federal law, litigation, COVID issues, non-COVID issues. And so we really appreciate your time and your attendance today. So with that, we will start our first topic, which is legislation, litigation, and other trends. For those that have attended in the past, you know that we like to do a top 10 or top 5 kind of list of issues, trends that we think our healthcare clients should be aware of. This year, there's just been so much going on from a state and federal perspective, from a COVID perspective, from a fraud and abuse perspective. We thought it would be helpful to lengthen this session so that we can cover and kind of issue spot for you a wide range of healthcare topics, things that have happened in 2020, 2021 that should be on your radar as a healthcare provider. So this is the agenda that we plan to cover in the next hour and 10 minutes or so. And with that, I will take us into our first topic, which is price transparency. This is the regulations were effective January 1 of this year. This is a regulation that applies to hospitals and the posting of clear and accessible pricing information online. If you're a hospital, hopefully you addressed this earlier this year and you are in compliance. But there are 2 specific requirements for posting that information. The first part is a comprehensive machine readable file with all items and services, including gross charges, discounted cash prices, payer specific negotiated charges, and de-identified in the sense you don't have to specifically identify which payer is the minimum or the maximum on the negotiated charge. The second requirement relates to shoppable services, and I'm posting at least 300 shoppable services or as many as the hospital provides if less than 300 services. And under this requirement, the language must be plain and with descriptions that are easy for the consumer to understand. And again, you have to provide the same sorts of information with respect to the discounted cash prices and the payer-specific negotiated charges. From a monitoring enforcement standpoint in 2021, so far, CMS, the Centers for Medicaid Services, have really taken more of a light touch with respect to enforcement. CMS is clearly out there looking to see if hospitals are in compliance, if they have this information posted on their websites. But so far, the enforcement has been more of compliance assistance or warnings and an opportunity to correct, get the information on your website, as opposed to an assessment of civil monetary penalties. But this likely is changing for 2022. So it's important that if you haven't got everything up to date and compliant with posting this pricing information, that you do so. In the proposed rulemaking for outpatient prospective payment services, or the OPPS rule, HHS CMS has signaled that they're going to take a stronger enforcement in 2022 in the sense that they're going to be increasing penalties for noncompliance. And you'll note on the last bullet on this slide that they're proposing a minimum civil monetary penalty of $300 per day for smaller hospitals with a bed count of 30 or less, and $10 per bed per day for hospitals with a bed count greater than 30, up to a daily dollar amount of $5,500. So this could get pretty expensive very fast if you're not in compliance. So just make sure if you're a hospital, this is on your radar and you've got all your pricing information in accordance with the price transparency rule before we roll into 2022.
So the next one's mine, the Competitive Health Insurance Reform Act of 2020. This was enacted, signed into law in the closing days of the Trump administration. And it reflects the culmination of about 10 years of effort by consumer groups and provider groups. You can see the second bullet point there, what Consumer Reports had to say about it. The general background of this is that in 1944, the US Supreme Court ruled that insurance was part of interstate commerce. And when it did that, it overturned an 1869 decision. The National Association of Insurance Commissioners became concerned about their turf, and so they hustled around and successfully obtained the passage of what's called the McCarran-Ferguson Act that provided an antitrust exemption for insurance companies, at least with respect to what's called the business of insurance. And that has generally been interpreted rather narrowly to focus on the policy relationship between the insurer and the insured, and doesn't necessarily carry over to insurer-provider contract issues. The law itself is very brief. The third bullet point there is almost the entirety of the law. It simply says the exemption is repealed as to health insurance, including dental. There's been some questions about the dental insurance plans also that consumers have raised and provider groups have raised. So the exemption as of January is no more. First bullet point there, you can see the Justice Department welcomed passage, and this would of course still been the Trump Justice Department. And it immediately filed a brief down in a Florida case in a dispute between a large agency and Blue Cross Blue Shield down in Florida. I don't know what the result of that is. That's still pending. And this summer, the American Hospital Association sent out, I guess you'd call it a white paper, to the Department of Justice and the FTC, asking them to, now that they have authority, look into conduct by commercial insurance companies, particularly picking out the Blues and United Health. Bait and switch coverage, there is when insurance companies change coverage midstream, halfway through the coverage period. The pharmacy restrictions essentially mean that the provider is required to utilize the drugs brought to them by patients that are supplied by approved pharmacies. And then the biggie, I suppose, is the United acquisition of physician practices all over the country. It'll take time for this to pan out, whether it's as significant as all these consumer groups have advocated for 10 years. We'll see.
I'm going to talk about the 340B program. If you're a critical access hospital, a rural health center, some other provider types, you may be familiar with this program. Requires Medicaid participating pharmaceutical manufacturers to sell outpatient drugs at a lower price. And the idea, of course, is to allow these providers to indigent or high Medicaid populations to be able to stretch federal resources farther. And it's administered by the HRSA. As you see on the next slide, there has been a attempt on the part of various drug companies, including a lot of the biggest drug manufacturers in the world, to crack down on what they have asserted is abuse of the 340B program. So in summer 2020, many of our Kansas hospitals received letters from drug companies that asserted that they would refuse to grant 340B discounts, further 340B discounts for drugs that are dispensed by a contract pharmacy rather than in-house pharmacy. And of course, many hospitals and rural health centers and other 340B eligible entities don't have an in-house pharmacy. And a lot of them contract with one or in many cases multiple pharmacies just for the convenience of their patients to administer their 340B drugs. This is essentially an attempt to try to limit the use of contract pharmacies the claim that the drug companies have made is that there's some abuse of the system that's happening, that there's duplicate discounts, that these contract pharmacies are enabling, and they're not following 340B requirements closely enough. So they've, in addition to outright, in some cases, barring the use of contract pharmacies or multiple contract pharmacies in any case, these companies are also have made pretty extensive demands for claims information regarding contract pharmacies and the provider and the contract pharmacies compliance with the 340B program. I think it kind of remains to be seen how this is all going to play out, as we can see in the next slide. The HRSA has, I think, taken a firmer stance against this kind of abuse. So their position has always been that this is not permitted, that this kinds of restrictions on the use of contract pharmacies is not permissible. But there's been some question about how forcefully they're willing to push back against the drug companies on this. HSRA did create this plan to settle disputes between providers and drug companies, including the kind of disputes we're talking about here, basically in an alternative dispute resolution process, arbitration process. And it would allow providers to challenge the denial of discounts through contract pharmacies. But this was ultimately enjoined by U.S. District Court because on the basis that the HHS hadn't followed proper rulemaking requirements and implementing this policy. So that is now enjoined, which was a big win for, I think it was Eli Lilly and some other drug manufacturers. And the hospital organizations are now suing drug companies for failure to follow 340B requirements as they've been described by HRSA. That's still in litigation. But I think the good news from a 340B provider's perspective is that HRSA seems, as I said, more willing to try to push back on this, and we'll just have to see how the litigation plays out.
Good morning. I am tasked with talking about information blocking this morning. In the midst of the COVID-19 pandemic, ONC actually dropped its final information blocking rule. The rule was published on May 1st, 2020, and after several delays, it went into effect this past April 5th of 2021. With everything going on, it's most likely healthcare providers have not given much thought to implementing the information blocking rules and its requirements. So now is just a good opportunity to go into the basic concepts of the rule and become familiar with the various exceptions. The rule is applicable to healthcare providers, which includes a group of a long laundry list, frankly, of providers, including hospitals, skilled nursing facilities, large and small physician practices, and mental health providers. Health information technology developers are also actors as well, which means most, if not all, of our EHR vendors are also going to be have to follow this rule. Broadly speaking, information blocking is a practice that is likely to interfere with access, exchange, or use of electronic health information unless that practice is required by law or falls into one of 8 regulatory safe harbors. One of the key definitions for the information blocking rule is electronic health information, which luckily for all of us that are well versed in HIPAA, the ONC decided to align electronic health information with the various different definitions in HIPAA. So it's defined as electronic protected health information in a designated record set as defined by HIPAA. Regardless of whether those records are used or maintained for by a covered entity, is kind of an interesting caveat of the rule. But it's going to apply to electronic records that are used in whole or in part by physicians to make decisions about individuals. The AHI must be shared unless if it's prohibited by law or if an exception applies.
ONC ended up providing 8 different exceptions to the information blocking rule that, when invoked, do not constitute information blocking. Each exception is going to contain specific conditions, and that must be met to be able to invoke that exception. And the key to all the exceptions is that they cannot be invoked more broadly than necessary. Brooke and I have presented ad nauseum as to these exceptions, and I think as it runs, it's about a 2-hour presentation, so I won't go through all those exceptions and their caveats this morning. But a quick reminder is that the exceptions that involve not fulfilling requests are the preventing harm exception, privacy and security exceptions, an infeasibility exception, and an health IT performance exception. Exceptions that involve procedures for fulfilling requests, but being able to tailor those requests are content and manner. Think your form and format, HIPAA requirements, the fees exception, and the licensing exception. A couple of good reminders also related to the information blocking rule is that it is an intent-based standard for healthcare providers. The provider has to know that the practice was unreasonable and likely to interfere with, prevent, or materially discourage access, exchange, or use of PHI. On the other hand, your health information exchanges and health information networks and health IT developers of certified health IT must know or should have known that that practice was likely to interfere. Also, we're still waiting on some guidance from the penalty perspective, but at the end of the day, right now, what we do know is that healthcare providers will likely be referred to the appropriate agency for appropriate disincentives, whereas the OIG may impose a civil monetary penalty of up to $1 million per violation for health information exchanges and health information networks and health IT developers of certified health IT. Just as a real quick reminder, I mentioned it when I started, but the compliance deadline is April 5th, but for the first 18 months, so until October 6th of 2022, ONC has narrowed the definition of electronic health information to simply be that electronic information or data elements in the US CDI standard. So when you're looking at responding to requests and the implication of the information blocking rule, the information you're looking at is much narrower here at the beginning. The enforcement deadline is kind of to be determined based on the CMP final rule, which is not yet published, as I mentioned. The focus here, or the purpose behind all this, is to put patients in charge of their healthcare records. The final rule, if you read it from cover to cover, really outlines this idea that patients should be the driver of where their information goes, and to permit patients to access the information through smartphones, modern software, those different things. But at the end of the day, from our end of it in the healthcare industry, it's really just a paradigm shift. Under HIPAA, you may share protected health information under certain circumstances. Under the information blocking rule, it's this idea that you must share that information when someone requests it.
My name is Stan Andeal, and I'm going to talk about corporate practice of medicine and the doctrine that has been in Kansas for many years. If many of you or some of you don't know what we're talking about, I can summarize corporate practice of medicine, I think, in one sentence. The basic idea is that businessmen should not be making medical decisions, nor should they be controlling doctors who make the decision. The whole idea is to protect the relationship between the doctor and the patient. As I say, the doctrine's been around for many years. There's several cases. The first case in Kansas law is called Winslow in 1924, which is why I said it's been around for almost 100 years. Actually, you have to read the slide in reverse. Winslow had to do with a dentistry deal. The second case is Goldman Jewelry. It had to do with an optometrist controlled corporation. Zales Jewelry was also optometry. And I might make just a side comment that if you read the opinion in those three cases, and they're all old, but they're all Kansas Supreme Court cases, the language of the Supreme Court is very vitriolic. It's not nice at all about these optometrist companies and the dentistry companies. I mean, it's, you guys are bad people, get out of our state and leave the professional people alone. The next case, which I used to call the leading case in Kansas, is Early Detection Center versus Wilson in 1991. The facts in that case are pretty interesting. Early Detection Center is or was based in Topeka. It was a professional corporation that somewhere along the line did the legal work to drop their status as a professional corporation and convert to a business corporation. And the reason they did that is they wanted to sell, or they did sell, 40% of the stock to some non-doctors. I think the facts in the case were they needed the cash or wanted the cash to buy some sophisticated medical vascular equipment. And then Dr. Wilson who had worked for them while they were a professional corporation and worked for them for a year or two after they converted to a business corporation, left Early Detection Center, walked down the street, set up his own practice, and he was in violation of a non-compete. The company, Early Detection Center, sued him on the basis of his non-compete, his employment contract. He defended that case by saying, yes, that's true. I have an employment agreement, but that agreement should be non-enforceable against me because a general business corporation is not authorized to practice medicine in the state of Kansas. The only way that you can practice medicine in corporate form in Kansas is through a professional corporation following the statutes that were enacted back I think in the late 50s, early 60s. In fact, prior to this, you may wonder, what the hell is this guy talking about? I work for doctors who are incorporated. Well, that's because we have a professional corporation statute that now allows that those statutes require that the stock in a professional corporation can only be sold to a person, an individual, who is licensed to practice the profession for which the charter is granted. In medical cases, it means you got to be a doctor. At any rate, Wilson won that case. The Supreme Court said that he's right. A general business corporation cannot practice medicine. And their result was a refusal to enforce contracts. That's what the opinion says. And in this case, the contract they refused to give effect to is the non-compete. St. Francis Medical Center is a very interesting case because it followed Early Detection Center only by 2 or 3 years. That was when St. Francis Hospital, now Ascension in Wichita, had acquired, something like 110 employment contracts of doctors. And they acquired them, if some of you remember the PCA, Physicians Corporation of America, that's how they acquired these contracts. Dr. Weiss, who did not have a very successful practice, left. I think he was actually based in Winfield, but in the old Snyder Clinic. But he left, go to Iowa or Wisconsin or someplace where his mother lived. And he didn't have a geographical non-compete, but he had a monetary liquidated damages that he owed St. Francis, I think it was $50,000 for not staying for 3 years. They sued him. I doubt if they cared about the $50,000, but they didn't want to start a precedent. He defended that case in the same way as Wilson did in Early Detection Center, saying, look, St. Francis is a hospital. That's not a professional corporation. And they don't have, they're not a professional corporation and they are incorporated, and you ought to let me out of this deal. The Supreme Court, this is the one exception that the Kansas Supreme Court has made to the corporate practice prohibition of saying, come on, a hospital is different than the optometry deal or the dentistry deal or any of these other national companies. A hospital employs doctors. They should employ doctors. Their license not only allows them, but requires them to provide all kinds of medical services. And so we're going to create a judicial exception and say that physicians can be employed by St. Francis and other hospitals. There actually was an attempt to say you had to be a nonprofit hospital. And I think that was an attempt to screw Wesley Hospital here in Kansas, which was for profit. But the Kansas Supreme Court wouldn't go along with that. So they allowed that. Hadasol is the next case, which probably now is the leading case in Kansas. That's an interesting deal. Some of you are probably familiar. It's all based in Great Bend, Central Kansas Medical Center. People call it CKMC. Was a hospital that converted from a hospital to an ambulatory surgical center in 2011. This is all fairly recent, last 10 years. They signed an employment contract a year later with Dr. Hattisall, who was a family medicine guy. And that's what his contract said. He was signed an employment to provide family medical services. A year later, or 2 years later, in 2014, Dr. Hattisall didn't like what the ASC was doing with respect to his practice. So he resigned, goes basically across the street. Well, it's about 2 blocks away to the regional, Great Bend Regional, which was a newer hospital, and joins them. Not surprisingly, Central Kansas sued him over his non-compete. He defended that case in the same way that Dr. Wilson did in Early Detection Center and all these other cases around, saying, wait a minute, an ASC is not a professional corporation, and it is not a hospital like St. Francis, and you ought to let me out of my non-compete. The argument that Central Kansas made was that, well, wait a minute, we are still licensed as a medical care facility. And that's an important term. Anyway, Dr. Hattisall wins in the Barton County District Court on the basis of everything I've been saying. The Court of Appeals in Kansas reverses the case in favor of Central Kansas, in favor of the ASC, saying, well, it is a medical care facility. But that gets appealed to the Kansas Supreme Court and decided in just 2018, well-written opinions that cover the law in Kansas that go all the way back to the Winslow case in 1924. It gives you the whole history. Actually, it's the Court of Appeals opinion, I think, is probably the best written to give you the history of this corporate practice stuff. But it basically, the Kansas Supreme Court reverses the Court of Appeals, affirms the district court, and Hattisall wins. They basically said that an ASC license is primarily for surgery, not for family medicine, and therefore an ASC cannot do family medicine, and they let Hattisall out of the non-compete. Now, the final case is where I'm going to turn it over to Clayton. It's called Clinical Colleagues. I think they abbreviated as CCI, and that's a Hutchinson-based deal. So Clayton, jump in.
Thank you, Dick.
Stan.
So as the previous slides showed, in addition to the well-reasoned opinion that walked through the history of the corporate practice of medicine doctrine in the state of Kansas, there was a lengthy concurrence. He concurred in the case because basically he said this is what the law is in Kansas, but I think we need to revisit this issue because the corporate practice of medicine doctrine is antiquated and no longer reflects, proper policy determinations. And oh, by the way, why is the court determining policy? That should be done by the legislature. So if there's a case in the future that actually challenges this doctrine, I think we should take the issue up again. And this is really what CCI is. CCI was an out-of-state general corporation that had contracted with a local medical center to provide anesthesia services. And basically, it was a breach of contract case. The medical center decided to go in a different direction, got a new anesthesia services provider, and CCI said, well, hey, we have an agreement here. You breached that agreement. No, by the way, you hired one of our former workers or independent contractors, and that's in violation of their non-solicit non-compete. You guys are both in the wrong, both the provider as well as the medical center. And now they're seeking damages in federal district court here in Wichita. In full disclosure, I represented one of the defendants, but I'm just basically just reciting what the court's opinion was. Ultimately, the court viewed this as just a straightforward application of the corporate practice of medicine. Basically, you have a general corporation, CCI, who's contracted to provide medical care, which seems like bread and butter corporate practice of medicine doctrine prohibition. And that's basically what the district court said. In defense, or I guess in support of their argument, CCI said, well, hey, there's this lengthy concurrence basically calling into question this doctrine. And while recognizing that lengthy concurrence, the federal district court said you're barking up the wrong tree. I'm not the Kansas Supreme Court. The Kansas Supreme Court spoke clearly on this in 2018. If you wanted to challenge that, you should have brought this in state court, not federal court, which is kind of interesting. And I think is kind of probably one of the biggest points going forward, that if the corporate practice of medicine doctrine is to be challenged, the party that's wanting to do that most likely needs to bring a state court action, because at least one federal district court judge in our district believes that it's improper, and they're unwilling to certify that question to the Kansas Supreme Court. So if there is a case in which you want to bring down the corporate practice of medicine doctrine in the state of Kansas, it should probably be brought in the state court, not federal court, which I think is in a case where the factual underpinnings were pretty straightforward, and I think the application of the law was also pretty straightforward. I think probably one of the most telling things that came out of this case, which was just recently decided about a month ago, is that any challenge to the corporate practice of medicine doctrine, if it's going to be based on that concurring opinion in the Hattisall case, needs to be brought in state court, not federal court. So if you have that issue, it'd be important to discuss that with your attorney, because I think from a procedural standpoint, that'll be important if there is going to be a possible valid challenge to the corporate practice here in the state through the courts.
These are my slides. I'm Gabriella Grouse. I'm going to basically take you through a brief chronology of how CMS has treated remote patient monitoring. And we're going to start January 1st, 2018. So here CMS unbundles CPT code 99091, which immediately increases the amount of billable Medicaid hours for doctors and clinicians who use remote care services. And this has the effect that eligible practitioners can bill to receive separate reimbursement for the time spent collecting and interpreting health data that was generated by patients remotely and then digitally restored and transmitted to the provider within 30 minutes. And then in January 1st, 2019, CMS released 3 new separately reimbursable CPT codes. So originally under CPT code 99457, auxiliary personnel could only bill for remote patient monitoring services incident to the professional services of the billable or the billing practitioner. However, now under 99457, the auxiliary personnel can bill under the general supervision of the billing practitioner, while before it required the direct physician supervision. So now that means that auxiliary personnel no longer have to be physically present in the same building as the billing practitioner in order to bill for remote patient monitoring services. Then in January 1st, 2020, this created new add-on codes. So for each additional 20 minutes of treatment management, providers can bill CPT code 99457 for the first 20 minutes of additional clinical staff time that is used performing RPM activities. And then they can use CPT codes 99458 for each additional second and third increments of 20 minutes. And so next slide. In March through April of 2020, CMS gives some clarification as far as the previous guidance that it's released, and it confirms that RPM codes can be used for physiologic monitoring of patients with acute conditions also. So previously, they were only being used for chronic conditions, and CMS confirms that they can be used for acute conditions as well. RPM services can also be used for new and established patients. So previously it was just being used for established patients. CMS confirms it can be used for new patients as well. And finally, CMS confirms that consent to receive RPM services can be obtained once annually. Providers don't have to don't have to get consent every time that they engage in the RPM services. So then in January 1st, 2021, CMS makes it permanent and finalizes its proposal that allows patient consent for services, and it can be obtained at the time that the RPM services are provided. Finally, January 1st, it'll be effective January 1st, 2022. CMS released a new category of digital health services that reimburse monitoring of non-physiologic data. And this is called remote therapeutic monitoring. And it provides a broader use of cases and applications in patient care. For example, musculoskeletal system status, respiratory therapy status, therapy adherence, and therapy responses. So that is what we have so far from remote patient monitoring, and there will likely be more changes. So
I'm gonna speak just briefly about the changes to the MPFS, the Medicare Physician Fee Schedule, in the 2021 final rule. What we saw, essentially, the most notable thing we saw was a big increase in the number of RVUs allocated to E&M kind of services. And so we see a big jump in RVUs for family medicine and other specialties that provide a lot of E&M services. And that jump was even larger for care of existing patients. I think the number I'd seen as a CMS estimated about a 28% average increase in WRVUs for E&M services. So in order to maintain budget neutrality, which these things have to be budget neutral, at least on paper, that led to a decrease in offsetting decrease in the conversion rate, the RVU conversion rate. So what we see is a big increase in comp for E&M services and a net decrease in Medicare compensation for other cases. The complication that's come from this for a lot of our clients is that salaries and bonuses are also often calculated based on work RVUs performed in physician employment agreements and physician services agreements. And so we now have this big unanticipated increase in WRVUs that physician, family practice physicians and other kind of E&M heavy specialties are going to receive. And so this could lead to kind of sharp increases in WRVUs and sharp increases in comp. It also has made referring to survey data challenging. Survey data reflects, like MGMA data reflects surveys from previous years under previous billing circumstances, and big changes in the fee schedule make the survey data less accurate and useful. So we'll see what happens in the next year's next few years' surveys. But what to do about this is the next slide. And I think carefully reviewing your affected contracts, we're always happy to help with that, and determine if adjustments are necessary, what rights under the contract you have, if there is this big unexpected change in the fee schedule, or other kind of reimbursement dynamics, what rights do you have as an employer or as an entity contracting with a physician or other provider to make equitable changes to comp provisions to ensure that there's not a huge balloon in compensation or in bonus eligibility. I think in the future it would make sense, and we're trying to think through ways to build in better flexibility in contract compensation arrangements with physicians, reevaluating WRVU bonuses generally. Is this really the best way to measure productivity? Is there a kind of a better approach to use? Do we want to have provisions? I mean, it's real common in physician employment agreements to have provisions that are just automatically update RVU comp based on the Medicare physician fee schedule. Should there be some kind of review, automatic review annually of comp to make sure it's still consistent with fair market value and commercially reasonable. Those are things that we are always happy to discuss with you. But I think this big jump in RVUs has kind of should lead to some reevaluation of how our employment and physician services agreements are structured.
Sorry about that. Forgot about the mute. Rural emergency hospitals was another item that was adopted very late in the Trump administration. It was inserted in the Consolidated Appropriations Act of 2021, which is a massive piece of legislation. And the general idea is that CAHs and other small hospitals in rural areas can drop acute care services and still receive substantial Medicare reimbursement. It's closely follows on what Kansas Hospital Association developed some few years ago as a primary care model. I'm not sure that Congress particularly linked up with KHA's ideas specifically, but it is close. And the general idea is that the acute care hospital, a CAH, could basically transition down to an ED plus outpatient care if it meets various requirements. The conditions of participation are going to be key in that, but CMS has yet to publish them. Another key element will be the requirement of a staffed emergency department and how EMTALA requirements fit with that. Again, there's no guidance, but hospitals that want to convert to this have until January 1, 2023 to begin to do so, or that's the beginning date. The Medicare reimbursement is OPPS plus an additional subsidy. That's a somewhat complicated calculation that essentially divides an amount among participating CAHs. I've yet to see any numbers on that. A group in North Carolina that is reflected in the next slide, the North Carolina Rural Health Research Program. I think it's pretty well respected. Some PhD types did a study to try to figure out how many hospitals nationwide might convert to this status. As you can see, the projection is that 68 facilities nationwide would do so. They developed this using some algorithms based on factors related to closure of hospitals over the last 10 years, primarily long-term profitability, net patient revenues, and then case mix census figures. 68 facilities they project nationwide, 16 in Kansas. That's clearly significant to Kansas. I'm not sure about other states. They project that 27 states will only have one such facility. And so obviously a question is whether this really makes sense from a policy perspective, but nonetheless it's there and people are talking about it. And I'm sure that small rural hospitals that are in trouble will be evaluating whether this makes sense for them. One of the requirements of the federal reimbursement is that a rural emergency hospital be licensed as such at the state level. And so Kansas, this last session, developed a licensure mechanism. The licensure mechanism, however, the language didn't address quite a number of issues. The focus of the licensure was simply to say that that rural emergency hospitals can be licensed as such, not recognizing that licensure definitions in turn, in Kansas at least, tie into a number of other statutes and requirements, which include risk management, the Healthcare Stabilization Fund, and some others that are not on this slide. They also didn't address exactly how a board of a governmental hospital, which has pretty limited authority, as I'll talk about later this morning, how it would do this. And then it doesn't clearly discuss how a rural emergency hospital might transition back to critical access hospital if it so desires, if financial situation changes. There's just a whole host of issues at the state level is the bottom line. And so, again, this is one of those that the jury's out. It'll take another year or so, and I suspect we'll be talking about this next year with maybe a little more detail around it. So.
I'm going to address some behavioral health topics here for the next few minutes. October 10th was actually World Mental Health Day, and we saw quite a bit of conversation in the news about mental health and the toll that COVID-19 is taking on mental health. We know the pandemic has been devastating on the physical health of people, but the mental health effects, based on some studies that are coming out, could even prove to be even more endearing. The Kaiser Family Foundation and Lancet, a medical journal, have recently published some studies attempting to quantify the impacts of COVID-19 on mental health and well-being around the world. I could have chosen from several different graphs or diagrams to throw up here to talk about the impact of COVID-19 on mental health. I chose this particular one from Kaiser Family Foundation just because I think it's probably the most demonstrating of the impact. According to Kaiser Family Foundation, about 4 in 10 adults in the US have reported symptoms of anxiety or depressive disorder, up from 1 in 10 adults who reported those symptoms from January to June of 2019. Other impacts that adults are reporting on their health and well-being are difficulty sleeping or eating, increases in alcohol consumption or substance abuse, worsening chronic conditions due to worry and stress over the pandemic. So it's a huge impact on our society. From a global perspective, they're saying cases of depression have rose by 53 million, and cases of anxiety have increased by 76 million. Ultimately, what this means for providers, as I describe in the next slide, is that we're going to see a massive increase in demand for mental health services, which is going to be a challenge for us as providers because there's a chronic shortage of behavioral health providers. Especially in rural areas, you're seeing a lack of psychologists and other behavioral health centers that can help assist with these problems and these issues, which with the shortage of behavioral health providers means that we're going to see patients presenting in a crisis state to our hospital emergency rooms where we may not be fully prepared to see them. And so we have to be careful. Our hospital emergency rooms have to be careful with respect to boarding and treatment of these providers and care for them. We're also going to see patients that are not willing to see behavioral health providers due to the stigma associated with mental health issues. So a couple important considerations for more of your primary care or hospital emergency rooms when you're dealing with some mental health questions and patients is to be present and available to them, be willing to talk about it, be willing to give them guidance, focus on their specific issues, avoid labels of depression and anxiety because of the stigma attached to it. While we're growing in this nation of being willing to talk about mental health issues, focus on, okay, you're having trouble sleeping today, and look at those items. Normalize the emotional response. Make sure you note in their medical record how and to the patient about how mental health could be related to physical health concerns, and try and encourage additional treatment to the extent that it's available in your community. But it will be a crisis coming, and I imagine we will continue to talk about behavioral health issues in upcoming presentations.
All right, I'm going to take just a few moments here just to remind you all of important immunity that currently exists here in the state. But before I get to the substantive information, I want to point out that you should be seeing a little red box as well as a box that just popped up. It's our first poll. If you would like to get credit, please click yes, presumably. And we'll make sure to get that down. Alternatively, you can type in the highlight and red highlight below that number into the chat function if you're not seeing that box, and Adrian will make sure that you get credit for attending this presentation. So with that said, just want to highlight two things that are obviously very important to this audience. And that is the immunity that the state legislatures for both Kansas and Missouri have extended to providers, to facilities, and to others during this pandemic. Kansas was first to the show, I guess, in the sense that it first enacted our immunity statutes back in 2020. Missouri actually just passed this past summer its immunity statute, and doesn't actually take effect till, or it took effect on August 28th, 2021. Basically just want to do two things. First, highlight that this immunity exists. And then secondly, to say that there is a lot of things that are going to have to be worked out regarding this immunity. Obviously, presumably there have been a number of patients or residents that their loved ones or maybe even themselves believe that there was some sort of medical negligence that occurred. And so there's going to be a question regarding how far does this immunity actually extend. I think most people would agree that for a provider that's treating a COVID-19 patient, that's probably going to fall within the grasp of this immunity. As you start getting away from that provider dealing directly with a COVID-19 patient, so maybe you're talking about a facility that's caring for a long-term care resident and they have bed sores and infection and then ultimately die, I think there's going to be litigation regarding how far does this immunity extend. And so obviously at this point, it's very early. Kansas has had this on the books now for going almost on 2 years. Missouri, it's been much more recently that they passed this. So I imagine over the coming years, the boundaries of this immunity will be tested. But as we stand now, there's obviously a colorable argument that this immunity is very broad. Just want to highlight for you that the standard for Kansas for this immunity is basically indirect response to the COVID-19 or pandemic, whereas Missouri, it uses the immunity and ties it to COVID-19 exposure actions, which we don't have the benefit of having any court interpretation, but it seems to me, just reading the statute, that Missouri's is a little bit more narrow than Kansas, but again, we'll have to wait to see until we actually have the courts weigh in.
I'm going to move pretty quickly through this provider relief fund slides. You all know that the provider relief fund was instituted through the CARES Act last year, March of 2020. It was a $100 billion fund that has since ballooned to $178 billion. There was phase one, which was the automatic tranche that you didn't apply for, you just received. There's been phase two, phase three, and now we're on phase four, which is the application for phase four is due, I think, at the end of the month of October. But basically, the way the portal for reporting information, as you all probably know, was opened July 1, and we have basically HRSA is divided the funds into 4 time periods based on when you received it. So you'll see the periods there, and then instituted different spending deadlines based on the time period. One spending deadline has passed. That was the one in June 30, 2021, and some of you may have been involved in trying to frantically spend some money right before the deadline, like some of us were. If you just go ahead and go on to the next slide, the first reporting deadline was September 30. There's a 60-day grace period that I think I've heard some providers in Kansas are taking advantage of, and you're going to have 30 days after the end of the grace period, so December 30, 2021, to return any unused funds. I think, generally, I guess I have one more slide. I wanted to talk a little bit about the audit process, to the extent that we know much about it. HHS is authorized to audit to ensure that requirements are met and are authorized to recoup funds. We know that the first audits are going to begin this month or have begun this month, and that they've hired some outside accounting firms, some big four kind of accounting firms to assist in that audit, and that they're focusing first on big providers. And Clayton and Gary are going to talk a little bit about some of the enforcement activity we've seen in litigation and settlements regarding PRF, usage of PRF or misuse of PRF funding in their presentation this afternoon. So stay tuned for that.
So Section 1557 compliance, we're seeing a resurgence in this particular issue and want to make sure it's on everyone's radar. Just as a refresher, Section 1557 was part of the Affordable Care Act enacted in 2010. And as part of that law, essentially Congress defined sex discrimination to include gender identity and charged the Department of Health and Human Services with developing regulations to enforce the legislation. It took HHS several years to put together its rulemaking, where it incorporated a definition that would have been consistent with the Affordable Care Act's definition of sex discrimination, explicitly including gender identity, sex stereotyping, and termination of pregnancy. Since 2010, we've had litigation ongoing with respect to Section 1557, HHS's 2016 rulemaking. So in 2020, HHS decides that it's going to change its rulemaking and narrow the definition of sex discrimination to remove sexual orientation and gender identity, which led a federal judge to say, hold on, HHS, wait a minute. If the Affordable Care Act defines sex discrimination to include gender identity and sexual orientation, you cannot issue rulemaking that would be contrary to federal law. So this has continued to evolve since 2020. There is a notable case, the Bostock versus Clayton County case. It was actually an employment case involving three different cases that were combined into one. And the allegations involved two individuals fired for being gay, and then the other individual alleged being fired for being transgender. And so what came out of the Supreme Court case was the principle that if an employer who fires an individual merely for being gay or transgender, that would violate the law. So that made all of us think about Section 1557. What does that mean going forward in the healthcare context? Is that going to transcend over to the healthcare context? And we got our answer in May from the Department of Health and Human Services, where they said they were going to interpret and enforce Section 1557 compliance in accordance with the Supreme Court's decision, which means discrimination on the basis of sex includes discrimination on the basis of sexual orientation and gender identity. So here, the takeaway for you all is to make sure that you're aware that we're going to start seeing HHS focus more on Section 1557 compliance. It's going to include discrimination based on sexual orientation and gender identity. So you want to make sure that you've got your non-discrimination statements updated to include sexual orientation, gender identity. You want to make sure you've got your non-discrimination policies updated. You've got your grievance policy and procedure in place so that if you have a patient that believes they've been discriminated based on gender orientation or gender identity, they know the process for making a complaint within your organization so it can be investigated and corrective action implemented if needed.
Thank you, Brooke. Next up, I'm going to be discussing a 2019 Supreme Court case, ASAR versus Alina, and sort of its outstanding questions that are still percolating up and are still being resolved. So by way of background, ASAR versus Alina dealt with Medicare reimbursement rates for hospitals tending to lower income patients. Basically, the formula that Medicare or CMS was proposing to use was not subjected to the notice and comment rulemaking process. Rather, CMS came up with its standard and basically posted it on the internet. which shortly thereafter resulted in a lawsuit being filed by, I believe, a number of healthcare providers, basically saying that, hey, this affects substantive rights and that this is altering our reimbursement or affects our reimbursement rates, and therefore it needed to go sort of towards the or through this administrative process that we're familiar with, which is the notice and comment rulemaking process. And this case, all the way up to the Supreme Court, folks thought was probably going to be resolved on the APA, the Administrative Procedures Act. But ultimately what ended up, there's a Medicare Act statute which talks about administrative guidance and when it must undergo this more formal process as opposed to just CMS coming up with a standard and then articulating it and claiming that it's guidance. And that requirement is what, as the Supreme Court pointed out in its decision, was substantive legal standard, which is kind of a nebulous term and probably needs some unpacking. And that's what the Supreme Court, we thought they were probably going to do if they actually addressed the Medicare Act standard as opposed to the APA standard. But as the Supreme Court sometimes does, it sidestepped the issue and it said, because this case involves reimbursement rates, that obviously is a substantive legal standard, and therefore we don't actually have to define it. We just know that it's met here, which has caused a number of questions, and I guess is why it's ultimately in this presentation, because in the years following the Azar decision, HHS has issued some informal guidance. It's the two pieces of guidance here would be a memo that was first circulated by HHS back in October of 2019, and then an advisory opinion that was issued a year and some change later in December of 2020, basically saying this is what we believe the substantive legal standard is. And basically what it attempted to do is HH said that if the standard is closely tied to a statutory or a regulatory requirement that did go the formal rulemaking process, then it most likely is not a substantive legal standard. Rather, it's more of an interpretive standard, which would not require formal rulemaking. But if it does deviate or creates this new standard that's not really found in any existing law or properly enacted regulation, then there could be an issue here. And usually how this comes, how it manifests itself is in affirmative cases brought by the Department of Justice. So as Gary and I have talked about, I think during the last two Health Law Institutes, the False Claims Act, which basically the government is acting like a plaintiff or acting through a relator, claiming that, in this particular context, a hospital or provider or group had basically taken money or gotten money that it wasn't entitled to. And so usually, or sometimes that's based on regulation or guidance that had been issued by CMS. And so those cases were all kind of cast into question by the Azar decision and then the subsequent guidance offered by HHS. And so that leads us to where we are today, which is we're still trying to figure out what does substantive legal standard mean. And there's actually been, or there is currently, a number of cases percolating up from the lower federal courts, which I think have a shot to ultimately be decided by the United States Supreme Court because of just its sheer importance. And right now, some people may be thinking, well, local coverage determination, LCDs, that seems to me almost like a substantive legal standard because they're basically filling in what does medical necessary mean. And the Ninth Circuit, in a decision this past year, said that LCDs do not constitute substantive legal standards. And so therefore, the action in that case, which I believe was an FCA action, could proceed because it did not violate Azar's principle. That case, obviously, I think has a shot of going up to the United States Supreme Court. There's another case coming out of the Eastern District of Pennsylvania, which is Polanski versus Executive Health Resources, Inc., where there was an FCA false claims action that was brought, basically saying that the hospital's practice regarding the inpatient rules were wrong, and the hospital had basically, or the medical center had defended, basically saying that this inpatient rule never underwent formal rulemaking, and therefore this is not a standard upon which an FCA action could be based. The district court actually bought that argument, which obviously, if that were to become the law of the land, there could be a number of causal effects that would arise from that. That case was appealed to the Third Circuit. It's still pending. So bottom line is there are still a lot of questions, despite the fact that AZAR was decided 2 years ago. There's a number of cases percolating up, so keep your eyes open. I would imagine as these cases start coming up and we start getting circuit splits or the court grants cert, we'll be having a news release for that, because those could have huge implications for you going forward.
Okay, so House Resolution 7898. This was recently released, and it amends the Health Information Technology for Economic and Clinical Health Act. So basically it requires that the Secretary of Health and Human Services consider your recognized security practices. And this is a huge opportunity for mitigation, but your recognized security practices need to fall within the definition, which it defines as those standards, guidelines, best practices, etc., that are developed in accordance with the NIST standard or with the Cybersecurity Act of 2015, and then the other programs that address cybersecurity. There are a couple requirements. The security practices have to be in place for the previous 12 months. And then if they're in place, the secretary will consider them, and they may mitigate fines, may mitigate any type of remedies that you may be responsible for, and they could even result in early termination of an audit. So it is very much worth implementing those security practices.
Missouri health law updates, just a couple things that we want to touch on that happened in the last year or so. So first off, Missouri Supreme Court upheld Medicaid expansion in Missouri. So this had kind of an interesting pathway to expansion. And in 2020, Missouri voters actually approved a constitutional amendment to expand Medicaid coverage to an additional 275,000 individuals in the state. In response to that, the legislature took action in the 2021 session and decided not to fund the expansion, and obviously the mandate from Missouri voters. This went up to the Missouri Supreme Court, and the Supreme Court ruled that the Department of Social Services had to comply with the amendment, and regardless of whether the legislature was going to fund it or not. So at this point, enrollment for those newly eligible individuals has begun. But it's still kind of a question mark on I think the funding piece with the legislature withholding funds at this point. And the other item in Missouri to keep or have on your radar is the statewide prescription drug monitoring program. Up until June of 2021, Missouri was the only state in the union that did not have some sort of statewide prescription drug monitoring program. Certain counties, I think maybe Jackson County and St. Louis County had smaller, more regional prescription monitoring, but there wasn't a whole scale one for the state like we have in Kansas and the other 49 states. So with this passage of this law going forward, Missouri will be like the rest of the states, and providers prescribing controlled substances will have the ability to access the system in a way to hopefully identify potential abusers, cut down and help slow the opioid epidemic that's raging across the country.
I wanted to speak about healthcare supply chain issues. Every industry right now is experiencing supply chain issues. These and healthcare is no exception. These issues have kind of evolved over time. Seems like right now the real issue is just lack of personnel, staffing issues, and we've seen staffing shortages delay shipments and performance, and make locums and other staffing coverage difficult to get and expensive. On the next slide, I just wanted to briefly highlight force majeure provisions. These are contractual provisions that basically say, here's what happens if one party is unable to perform due to some circumstance beyond their control. And so there's been a lot of interesting questions about how COVID-19 and its various kind of effects implicate or trigger these force majeure provisions. And, you know, force majeure provisions can be written in a lot of different ways. Sometimes they're very, they have a very wide, all-encompassing kind of scope, like they might say anything outside of the control of the parties. Sometimes they're more limited to, you know, specific things like earthquakes, fires, natural disasters, that kind of thing. So in the last slide, just a few things to be thinking about, just in general regarding supply chain problems. What's the scope of your force majeure provisions in a contract? I think we probably historically haven't spent a lot of time negotiating force majeure provisions and a lot of vendor arrangements. And I think it's probably time to rethink that, be more careful about the language that's in there. How does exclusivity provisions, you know, if you have an exclusive service provider or vendor, how are those affected by a force majeure event or their failure to be able to provide a product? Do we have an exception to the exclusivity, how that's structured, something to think about? And what are our rights upon non-performance? Do we have the right to indemnity, collect attorney's fees? How are disputes resolved? These are all going to be important contractual items when we have staffing issues or other supply chain issues to keep in mind.
And with the last topic of today, and about 2 minutes to go, I'm going to talk about Medicare revocation and enrollment. I'm going to try and not talk too fast about this, but we've noticed recently CMS is watching your Medicaid enrollment applications and your re-enrollment revalidation applications. So we wanted to remind you of a couple of common reasons and common mistakes for adverse enrollment actions. One of the first ones is rejection, which is CMS can reject your application if you fail to provide information that is requested by your enrollment analyst within 30 calendar days of that request. Now, CMS at times when asked will give you an extension of that 30 calendar days, but make sure you work with your analyst to get that extension in writing if you do need it. But the common mistakes that result in rejection are the certification statement being unsigned, it being signed 120 days prior to submission. I had one of those happen recently when someone came to me to ask what went wrong, and that was one of the reasons. Failure to complete all the required sections, submitting the wrong application or the wrong information. They are running that information, they are checking it, they are double verifying it. If it's rejected, you have to resubmit. Another one is denial for not being in compliance with requirements. This is one where you're gonna actually get a denial of your enrollment application, but you're going to have to either submit a new enrollment application or appeal. So if you don't appeal, you can submit a new application 60 days following that denial notice. If you do appeal, you have to receive notification that the determination was upheld. We've seen this happen a lot recently because, again, CMS is watching and checking these. We've had someone recently that an administrator or exec that was on the enrollment application passed away, and we got a deactivation notice because that person had passed away and he was still on our records. So again, a couple of reasons for failing to deactivate. One common mistake is failure to update your change in practice location. The failure to respond to a revalidation request after you receive it, a defense is not, well, I didn't get it because we changed practice locations. You need to keep all that enrollment information current and updated so that it is active on your CMS enrollment application. Oh, and reactivation. Deactivation for failure to report the change of information or ownership or control. What you're going to have to do there is submit a brand new enrollment application. You're going to get a new PTAN with a new effective date, and the provider is not entitled to retrospective billing during that time in which it was deactivated. If you're deactivated for failure to respond to a revalidation request, what you're going to have to do is submit a brand new full application, but it's not an initial application. So you will maintain your original PTAN, but you'll have a gap in coverage because again, no payments are going to be made by CMS during the period of deactivation.
All right, well, that concludes our first session. Thank you, Amanda, and thank you to the rest of the panel participants.